Welcome to the Immigration Lawyers Podcast. I am the host, Attorney John Khosravi, and I practice U.S. immigration law exclusively. For more information about the program, please visit www.immigrationlawyerspodcast.com. Please note that this recording is informational only and does not constitute legal advice. Please consult with a licensed attorney for specific legal guidance that suits your case. Also, this recording is copyrighted and written permission is required for rebroadcasting. For more information about me, please visit www.jqqlaw.com. Hi everyone, welcome to episode 110 of the Immigration Lawyers Podcast. I'm immigration attorney John Khosravi. I'm really happy to have you joining me here today on this midweek quick agency update and just immigration thoughts. Middle of the week, I like to do short ones just to keep the momentum going. I really get a kick out of, doing this stuff and hearing the audience come back and enjoy the information that comes with it. And it's been such a wild week since the last time I talked. It seems like there's all sorts of craziness in the news between the president and the population reacting with it. So, one thing that's a somewhat positive news, but it might be a backhanded method by the state, which is that the travel ban cases have been surprisingly getting approved recently last couple of weeks without even administrative processing. And this has been happening in the various embassies within the Middle East. And people just going to interviews, getting approved, coming, and it's mind-boggling how that's happening because there's other cases that have been pending for like 3 years or so. Even since before the travel ban came into play, they were stuck in administrative processing and they were stuck with travel ban. And so those are getting approved, which is exciting for the people and the clients that are getting that. I mean, that's great. They don't have to wait and everything. But there's all these other people in line that haven't moved. There's been speculation that this is a move in response to the litigation that's been happening with, just on this show, that's all I talk about nowadays is federal litigation, especially on this matter. And so potentially it's a technique for a state to say, no, we're approving some waivers. This accusation that if waivers aren't being approved is incorrect. It might be a tactic that they're using. It's not well thought out because there's just so many samples and examples of cases where it hasn't worked out, it hasn't been the case. But for now, cases not going to embassies, especially immediate relative kind of cases, are getting approved. So that's an exciting thing. And I had one case myself that went to the interview. They said it's approved. We're still waiting on the visa, but that's great stuff. But on the other front, the attacks are still going on. There was a memo issued about TPS, temporary protected status, and TPS is a special humanitarian designation that was given permission by legislation from the Congress to designate certain countries as having issues, humanitarian or otherwise, that happen, and if the nationals of those countries in the U.S., they get what's called temporary protected status, TPS, where they can live here and get a work permit until the situation gets better back home and they can return. Now, there's been a lot of drama about this because, for example, there's been people from these countries that were here already without authorization, then TPS was announced, and then they got temporary protected status. So status is the key word because the way the statute is written, when you have TPS, you have status. And so what people, especially lawyers, have been arguing is that once you have status, if there's a reason where you can adjust status for employment-based or family-based case, even if you enter an EWI without inspection or admission or parole, you should be able to adjust status because that granting of TPS is an admission, and you should be able to, based on that, then adjust status. Now, the Ninth Circuit and the Sixth Circuit have accepted this argument that a grant of TPS is the same as admission. However, USCIS adopted a decision by the AEO that said TPS is not constructive admission or any form of admission, except for the 6th and the 9th where they've said that's okay, so that's an exception. However, they go on to say, other than that limited idea that when you're granted TPS it's an admission, it does not cure previous periods of unlawful presence. So there's other visa violations that admission is not an issue, not going to help them. So for example, someone comes here without admission and then marries a green card holder and files for adjustment of status. Well, if they're even in the 9th, let's say, and they file for TPS, get TPS, and they file for adjustment of status, that TPS would be an admission in the 9th, but not in most other circuits. But because the person had previous violations, that would be a problem for INA 245C because you can't adjust status if you've had any period of unlawful presence or have previous immigration violations, you can't adjust status in the U.S. So that wouldn't work. Now, marriage to immediate relative would work. I mean, like a spouse or parent or child of a U.S. citizen. But for those LPR cases and a lot of employment-based cases, the adjustment of status wouldn't work. Now, one thing I've always thought about is what about INA 245K? So a person came here EWI and then gets TPS and they're in the Ninth Circuit or the Sixth Circuit. Well, that's an admission. So there have been TPS is an admission in those circuits, and once you have admission with INA 245K, it makes previous violations subsequent to admission okay, and also previous violations in 245C are okay. So how does that work with employment-based, EB 1 through 4, counting EB 1 through 3, and some EB 4 cases for INA 245K? I mean, it's not a typical case that pops up, but that's an interesting thing that you could argue and say, well, based on INA 245K, TPS is an admission, and subsequent previous acts violations of status are not an issue for that. So that might be the case. So that's an argument. These cases don't pop up too often to be able to test them, but that'd be an interesting argument to make. Furthermore, in asylum news, there was a matter of LEA that the great Attorney General took on and redid and said that a person can't use a family member relationship to put themselves in a class that's within a particular social group for asylum purposes. So for asylum, you have to be a member of a particular social group. It's race, gender, different sorts. So I'm not an asylum practice yet. I can't remember all the code words and terms, but essentially they said immediate family member is not a unit that can be based on for a particular social group, and so that creates a problem, and it's going to throw that out there. And a lot of people have probably filed cases where people's families were targeted particularly, and they use it as a social group. Then all of a sudden that's no longer a basis for asylum. So that's a messed up thing when they change these things overnight. They had the same issue when they took away the domestic violence claim, and so these kind of things pop up overnight. That's the nature of immigration. I got I see those clients all the time. They ask questions about the future, and it's like we're not fortune tellers. I know we tell the future. Especially like I had a call today about a client who wanted to know timelines and stuff, and I kept saying stuff, and then the client would say, what about this, what about that? And after like 15 minutes, I say, you know what, and I should have just said this in the beginning, no one knows. They could just change things tomorrow. It could be faster, most likely it would be longer. Things would be on average today a certain way. In 6 months, everything would change. And that's the nature of immigration. That's always been, but especially under this administration. So don't make real plans about life until this is over. So your life is going to be on hold for a year or two until we figure this out, until they work their way out. Hopefully it won't be longer. And that's pretty much what I have to tell you. Because the first question people ask is, how long is it going to take? And there's no answer to that. Then how much it costs? And I'm like, well, you got to pay me for a consultation fee for me to tell you how much it costs. It's more because I need to know what kind of issues exist with the case and spend time on them and get to know with all that. But how long it's going to take is just such a crazy question. There's someone on Lister that said the USCIS website was not working and they wanted to check, case processing times. And I joked and responded back, what difference does it make? Those numbers don't mean anything. Now, if you're going to file a complaint or, say that things are taking too long, yeah, it matters there. But it's so sinister. They've increased the average processing time so high that it takes so long for you to be able to even make a claim, a motion to say that it's taking too long. For example, employment EADs, I think they used to be like if it's taking more than 4 months, then 6 months you could file a complaint. Now they're saying 7 or 9 months, and so hopefully by the 9th month you'll get a C9 adjustment EAD. But who knows? But so they really clean their hands of having to deal with that. Now, a really interesting issue that popped up is with regards to the visa bulletin being adjusted. And so there's family-based issues and employment-based. So first of all, family-based, the F2A category, spouse or unmarried minor children of green card holders, it became current recently. So that's a neat thing. However, based on the check-in with Charlie that happens regularly with the State Department, and they talk about how the timelines are going to go for the visa bulletin, they said that the final entry date is probably going to end like around September. It's going to be current through September, but after that, probably not. And the dates there'll be retrogression that's going to happen, probably pushing back to 2017 or 2018. So this is a short-lived kind of thing, and most likely things are going to be pushed way back. So yeah, if you have a case that's appropriate to file for adjustment, you really got to do it within this small window of opportunity you have. But if there's retrogression, it's going to take longer. It's just the point of if you're able to file for I-485 and get the authorized period to stay, and then hopefully get a work permit. That's the beneficial part. But it's worth doing if someone has an appropriate claim to adjustment at this time. But then they also go into the employment-based category. This was an issue that happened a lot, and we saw in the listservs we were talking about this. So what happened is the retrogression happened, very deep retrogression in the employment-based categories and for the August visa bulletin before August started. But in July, and this writing is from July, it was still current for a lot of cases for them to be able to adjust status based on EB2 and EB3 categories. But the next month over, on August 1st, those were going to go back, and the people would be locked out of that. And so a lot of people went to their EB2 interviews and they were fine, but they then went to their EB3, employment-based third category adjustment interviews, towards the second 2 weeks, the latter half of July. And the officers were like, well, the case is approvable, but we don't have any visa numbers left, so you have to wait till retrogression catches up and your priority date is current. And this is very frustrating because people are like, wait, the visa bulletin says it's okay. It's in August 1st is when the cutoff is. How are you doing this? And a lot of my colleagues were calling supervisors and filing complaints, all this kind of stuff. And as it turns out, this is what Charlie Oppenheim says. It says, beginning during the last 2 weeks of May 2019, the actual use of numbers by USCIS began to increase significantly in most employment-based categories. Then they says, what you heard is partially correct, blah, blah. For the employment third, or EB3, other workers preference category only, it was necessary to impose the August 2019 final action dates on future requests for numbers to control use within annual limits of those countries. So essentially they're saying we have to kick that retrogression in even sooner than what's listed on the visa bulletin because we're running out. And then it says USCIS will be able to continue processing such cases at their discretion and submit requests for visa authorization as they normally would. The difference is that the cases which are not within the August final action dates will be held in my database pending future availability of visa numbers, most likely effective October 1st, 2019. So essentially they're just saying, they ran out and they had to catch up. They cite the Section 1 language that says, if it becomes necessary during the monthly allocation process to retrogress the final action date, supplemental requests for numbers will be honored only if the priority date falls within the new final action date announced in this bulletin. If at any time annual limits were reached, it would be necessary to immediately make the preference category unavailable and no further requests for numbers would be honored. So it's a discretionary thing. It's not even discretionary, it's depending on how much numbers they have. And that could the numbers could run out even before the next month's visa bulletin kicks in. So that was the primarily agents updates that I came across. And so there's not much about that. If you wanted to tune out at this point, that was it. The rest is going to be just some interesting thoughts I had. There's been a lot of, the rhetoric of the president has been pretty ludicrous with regards to him saying, go back to your country, and then a shooting happens with persons worried about, computers taking over AI and also immigrants taking jobs. And I just thought I got to talk about this a little bit. And I'm like, how should I talk about this? And I just thought about immigration, how it all fits in the history of immigration. Because I remember in ref passing, someone had read somewhere about this one case, and I thought this might be a good time to talk about it. And this is in regards to cases that happened back in 1922, actually. So 1922, it's between the two wars. Let's see, World War I ended in 1919. 3 years later, from the end of the war, this is pretty much the Roaring '20s. They're really souping up the stock market, pumping money in. The Federal Reserve at that point had started opening itself up to loans. Bank of America, Amerigo Vespucci, what is his name? Bank of America. I forgot the guy who actually made Bank of America. It's an Italian guy, and he was really pushing for more loans, for home loans, so they could, just like the the 2000s, to cause home prices to go up, loans to go up, and get more liquidity in the marketplace. People were buying appliances and on loan and layaway, so that was boosting things and pushing a lot of money into the system. So this is the atmosphere that was going on at the time. And so there was a case. This is a case called Ozawa v. United States from 1922, and this was a unanimous decision by the Supreme Court. And so I'm going to be going over 3 cases that are interrelated in the same period. And it just shows you just what was going on that time, this time, and I'll talk about it more. So in Ozawa v. United States, we had a guy who was essentially a green card holder who requested for naturalization in Hawaii. And he was denied there. Now, the guy had continuously resided in the United States for 20 years, was a graduate of Berkeley, and had 3 years as a student. He had students in American schools. His family attended American churches, and he maintained the use of English language in his home. And so he was qualified, under their opinion, for the character and moral requirements and education part for getting naturalized. And this was a Ninth Circuit case. So this is the Ninth Circuit now that we look at as the more liberal kind of case where it came out of. Eventually it's made to the Supreme Court. And the basic question was this: is one who is of Japanese race, this is a Japanese national, and was born in Japan, eligible to citizenship under U.S. naturalization laws? So the provision of naturalization laws at the time was that this says the provision of this title shall apply to aliens being free white persons and to aliens of African nativity and to persons of African descent. So it says in all the naturalization acts from 1790 to 1906, the privilege of naturalization was confined to white persons, with the addition in 1870 of those African nativity and descent, of those of African nativity descent. So then it says so essentially, citizenship was, in their opinion, just for white people and people of African descent. Essentially, the slaves were freed from Civil War. It says, if Congress in 1906 desired to alter a rule so well and so long established, it may be assumed that its purpose would have been definitely disclosed, and its legislation to that end put in unmistakable terms. So this is unanimous Supreme Court saying, listen, it's clear Congress made it specifically like this. Now, the Japanese guy on his behalf says it's urged that it should give the phrase the meaning which it had in the minds of the original framers in 1790, in that it was employed by them for the sole purpose of excluding the black or African race and the Indians then inhabiting this country. So the argument that this racist law exists that says only white people and black people could get citizenship, not other people, the counter argument was that a racist argument saying, no, the racism is okay. It's just that it wasn't including us a part of that umbrella. It was really just trying to kick out black people and Native Americans. So that was a counter argument to to that. And the court says it may be true that those two races were alone thought of as being excluded, but to say that they were the only ones within the intent of the statute would be to ignore the affirmative form of the legislation. And then it goes on to say the intention was to confer the privilege of citizenship upon that class of persons whom the fathers knew as white, and to deny it to all who could not be so classified. And it's such a weird term to say the fathers. They do that a couple times here. When they talk about the founding fathers, they say the fathers. It's weird. And then it goes on to say it is not important in construing their words, consider the extent of their ethnological knowledge, or whether they thought that under the statute that only persons who would be denied naturalization will be Negroes and Indians, quote unquote. It is sufficient to ascertain whom they intended to include, and having ascertained that, it follows as a necessary corollary that all others are to be excluded. So there's more to it I'm going to be going over, but it's crazy that this is the language of the court. They go on to say, manifestly the test afforded by the mere color of the skin of each individual is impracticable, as that differs greatly among persons of the same race, even among Anglo-Saxons, ranging by imperceptible gradations from their fair blonde to the swarthy brunette. And I've heard swarthy being said as a joke, but that's the first time I read it in a Supreme Court decision. But to the swarthy brunette, the latter being darker than many of the lighter-hued persons of the brown or yellow races. Hence, to adopt the color test alone would result in a confused overlapping of races and a gradual merging of one into the other, without any practical lines of separation. Okay, so then it goes on, with the conclusion reached in these several decisions, and it cited a bunch of decisions that said white people are different and all that kind of stuff, we see no reason to defer. Moreover, that conclusion has become so well established by judicial and executive concurrence and legislation acquiescence that we should not, at this late day, feel at liberty to disturb it in the absence of reasons far more cognate than any of that which has been suggested. So, I mean, that's a cite to another case, but they're saying, dude, that we've already, in 1922, we've drawn these lines of what people are, what they are. It says, a large number of the federal and state courts have so decided, and we find no reported cases definitely to the contrary. These decisions are sustained by numerous scientific authorities, which we do not deem it necessary to review. So then they go into the scientific aspect of races being different, and the argument is that white is different, and Congress said white is this. Not to say that one is better than the other, and that's actually, they go into that. But they say, of course, there is not implied either in the legislation or in our interpretation of it any suggestion of individual unworthiness or racial inferiority. These considerations are no manner involved. So it probably is involved, but I can understand what they're saying is that they're drawing the line as to the color. This is the 1922 decision. So this is less than 100 years ago. This was the unanimous Supreme Court decision on race and who's allowed to become a U.S. citizen, who's the other in the society, and who's part of the in-group. And so the same year, part of that same group decision, there was another decision called Yamashita v. Hinkle. And this is the consequences of a decision where a foreign national that's not white or black can't become a U.S. citizen. In this case, Washington State, which is one of the most liberal states now, said that passed laws with regards to alien land laws. And they said that essentially a person of Japanese race, which was the situation in this case, was not qualified under the laws of the state of Washington to form the corporation proposed or to file articles naming them as sole trustees of said corporation, and they were creating a real estate trust, a holding company. And so because they couldn't be a citizen and they were Japanese national, then they couldn't own property in the manner that they wanted to as part of this business operation. And it wasn't until 1966 that this specific land law was appealed or repealed and taken away. So there was direct consequences. Maybe, just not being able to vote and take part in civic society is its own thing, but there was all sorts of ownership and property ownership issues that the Japanese faced in 1922 that became problematic. And the consequences are there. They couldn't rise, and it's just intentional. These kind of laws limit the opportunity of rivals coming in. I'm going to go about this later, but a lot of this is about economic opportunity scarcity. It's talked about racial terms of hate, inferiority, which there is in some segment. They want to put people down to make themselves feel above. But there's always that connection that goes to property ownership and money, and let's keep the money for ourselves and not let other people come into play. So the third case that comes up is the third and last case is a case called United States v. Bhagat Singh Thind from 1923. And this one changes up. This time it's not a Japanese national, East Asia, it's South Asia. It's a Hindu or a person of Indian origin. And this person argument was, I'm from a high caste of the Hindu society, a full-blooded Indian, which is part of the Aryan group, and so I'm a white person, I should be able to be naturalized. Now, just to give some background, the term Aryan is now considered an ethno-linguistic branching of languages, and they assume that the people come from the same group, which is a group that was around the Caucasus or north of that. Eventually immigrated one part to Germany, which Aryan in regards to the rise of Nazi Germany. A group went to Iran, and Iran means the land of Aryans, and the Persians are the subgroup of that. And then another group went to northern India, and so the Hindu group that this guy's arguing is saying, I'm an Aryan, I'm white, I should be able to naturalize based on these laws. And you see, the arguments that come against the racial aspect of the naturalization laws at the time were not geared to saying it's just unconstitutional, you shouldn't differentiate between people like this. It was the fact that, yeah, it's all good, but I want a you. So that's the way I was looking. And the court goes and says, you know what, regardless if this is a case, right now you're different races. Maybe, generations ago you're one family and stuff, but when you come down and break apart, these are each of their own things, and we could distinguish that your color is different, you're a different group. Even if you're, lighter skin in this high caste of Indian society. And then they goes into this thing where they say, even, for example, the term Caucasus or Caucasian is mixed. Like some people say, not only Hindus are included in Caucasian, but Polynesians are. Even the Hamites of Africa would be. And that was an interesting little reference they made to the Hamites of Africa. For those that don't know, in biblical studies in the Torah, there was Noah's Ark. Noah was the guy who made the ship, and God flooded the earth and only saved his family. He had several sons. And one day after the flood ended, Noah went and got drunk, and for some reason took his clothes off and got naked. and the sons came to dress him, but all of them, shield their eyes and didn't look, but one of his sons, Ham, looked. And it was such a bad thing that his son was cursed, and he had to leave, and the curse was that him and his offspring would be servants of the children, serve as a servant, so they would be a lowly group that always has to help other people. And so, as racist history would be, they put the name of Africans as Hamites because they assumed that, well, if they're slaves here, then they must have been the descendants of Hamite. So in one sense, it's a way to use biblical history to subjugate a group and make it justified. But then it undermines them because if they were Hamites, that means they come from the same race, and the Hamites, Africans used to be white too, or whatever color we used to all be, they're one. So that undermines that argument that they're a certain race and all these other things that come about. But I mean, they're distinguishing over time these races develop. So this is like garbage science, and I don't want to go too much into it. But this is my point in going through all this is that it really sounds like the Klan was ruling the government at the time, and so. This was the situation where we had a whole government structure just talking about this kind of garbage, and this was like the thought process of the top legal experts in the country. When you look at who was representing the Supreme Court at the time, the Chief Justice in 1922 was former President Taft. So Taft was a guy who he attended Yale, he was a member of Skull and Bones, he was a Solicitor General, went through the Sixth Circuit Appeals, was appointed the civilian governor of the Philippines. And a lot of people don't know about the history of the Philippines and the U.S. involvement. When the U.S. became an empire, they defeated the Spanish. And the Spanish had colonies all over the world, including Spain, which we got in Puerto Rico, which is essentially still our colony. But they also owned the Philippines. So U.S. tagged up with the Philippines rebels to overthrow the Spanish. And once overthrown, U.S. took custody of there and instituted a horrible, gruesome control of that country, mass slaughter control. If you look in the history of the time, it was widely debated in American society whether this is appropriate or not. Mark Twain, one of the greatest Americans ever, he was one of the people who was really against the subjugation of the Filipino people because he saw how bad it was and also how it changed the nature of our country. It was a big debate 100 years ago when the U.S. was taking over Philippines and whether we're an empire or not. Nowadays, people don't even realize the U.S. is an empire and our imperial presence everywhere. But there was a massive debate. Unfortunately, those who wanted peace and prosperity lost out to those who were taking a lot of advantage or control of that society. But my point of bringing this up, this was the Chief Justice of the Supreme Court of the United States, and he signed on to the fact saying there's Hamites, and then there's, there are differences in races, your colors, this, that, all this garbage that we went through, which was intentionally designed to not allow opportunity for other people, that was entrenched in our society. The next person on the court, which is well known, Oliver Wendell Holmes, which was the justice at the time. All we hear about is how great this guy was. He was one of the greatest legal scholars ever. I mean, he did some stuff about, clear and present danger, which you learn about in law school, and Schenck for the United States, a lot of stuff, which is good. But he signed off on this decision, no concurrence or dissent opinion. So to think that he was some great guy, that's what it was. And then finally, the third one I want to mention is Justice Louis Brandeis, and he has a law school named Brandeis. He has a law school named after him too. Harvard law guy, this thing got the best grades ever, progressive. Well, he was also the first Jewish person named to the court, but he also signed off on this garbage decision. So it really is troublesome to know just 100 years ago, the complete conclusion of our federal government was that there was this distinction on races, and that distinction was enough to not allow certain people to gain property or have some sort of independence in their life in the United States. And not only was this in the executive branches, both federal and state level, but it was also within the legislatures that passed laws, both in the state level, as we saw in the Washington state case, but also in the federal legislature, because at the same time, these were the times when they created the restrictionist laws on East Asians being able to immigrate to the United States and having quotas on people. And the court cites those and says, look, this is the legislation that we're putting into place. This is how it is. So, it does seem like, there's a white power group going on and controlling it. And, it does offend a lot of people, and it is offensive. But as I noted here, the arguments made by the foreign nationals weren't much better. They were also going and saying, yeah, it's okay that these racist laws exist, but we're one of you. And when you look at these nationalists, because you might be tempted to be like, oh yeah, they're so mean to the Japanese, they're so mean to these Hindu or Indian people. This is 1922. This is the time that the Japanese Empire was rising. And they attacked South Korea and treated them like horrible. I would say, saying they treat them like garbage is being kind. Then they went and attacked China and they did human laboratory tests on Chinese people that were the most gruesome, if not worse than the Nazis, on what they would do in their testing on Chinese people. And because they thought that non-Japanese, not part of that race, were subhuman, they could do whatever they want to do. All over South Asia as well. The island hopping campaign we had there, the U.S. would see what kind of gruesome things they would do to the people over there. That was their opinion. They sided with the Nazis to become the Axis powers. So, to say that, it's like, oh, these Americans were just the only bad people in this, and they're so mean, and they have a history of racism, it's not the case. Being born here, but my family's background, I've traveled the world. This was a situation everywhere. Just looking at that Indian situation about the Indian caste system, that's the most disgusting system that exists, and it's ingrained in the religion, that there's a caste and you're better than other people, and the lowest caste, clean toilets, and people rape and pillage and treat them like garbage, but the higher ones are different. That's not any better. And so my point in this is, it's not necessarily an issue of saying white people have privilege and white people have rights, and these are the things that are popping up in the news to kind of go back where it came from. The white privilege is going craziness, and that is the case, but there's a privilege everywhere. It's not a white person problem feeling dominant, this is a human being problem. And so if we're trying to solve these issues, just attacking white people will just undermine what we're doing. We really need to look at it on a human basis and take it on a larger scale than that. This is primarily an issue of an economic issue of scarcity, and we see the property rights things attached to citizenship. This is one group feeling that they're going to lose out, and might be justified in the old way of thinking, because historically there was opportunity cost and there was scarcity. It's economics. If I don't get it, then you get it, then I don't get it. And you may not give it to me, and you might get power and prevent from me. And that's been the historical nature of human beings, to get that power and prevent everyone else from getting it. That's the fear we feel on a deep level from our tribal history and our DNA. And when that comes out, whether you're in Japan, whether you're in India, whether you're in Iran, whether in Germany, in Africa, I see a lot of people, African Americans saying, there's racism and stuff. Go to Africa. It's not like, just the idea of saying Africa is racist itself by a lot of people here of all colors, because Africa is a huge country. A Kenyan is different than a Nigerian. A South African is different from a Libyan or Egyptian. They're all different people. The skin tones might be a little darker, but it's like saying a French person is the same as an Australian. Their skin tone may be more similar, but they're completely different people. And they all have their own kind of imperial ideas and racist ideas. So my point in all this is that, we got to challenge the economic thinking that causes people to get to this. Now, surely there is a portion of that population that's racist and wants to put people down from all over the world. It's a way of making themselves feel superior, and it's a deep psychological insecurity. But to me, when things get mass movements, it really comes down to economic situations. That's what gets people going. When you look at like elections for president, for example, if the economy is good, the president gets reelected. If the economy is bad, a new person comes. This happened to George Bush Sr. And so it deeply affects people. It's just literally food on the table, or how wealthy people are, how comfortable they are. And that's what it goes to. And it's not even just about race or caste or something like that. In immigration laws, immigration attorneys. I've been doing this program, I think 5 years now. I can't remember when I started, but it's been years I've been doing this. And what I do is I come on and I talk about what I learned this week. And I spent hours and hours studying this stuff, and then within 20 minutes I tell you what I learned so you could use it. Now, in the old school way of thinking, I'm like putting myself on an economic disadvantage because I'm spending all this time doing all this study, and then I'm just giving away for free through this video recording, this audio recording. So, you would think in the old way of thinking, again, the old way of thinking, that this idea that there's scarcity would harm me. But we're in a new world. It's not the old days where everyone's a dummy and we only have material resources and we got to, take as many as we can. We're on a different level in an intellectual society, a knowledge society. And a knowledge society, the way it could work is that we could exponentially grow it without, stepping on each other's toes. And that's really the fact. And when I look at my history, every year when I come on this show, every month, every week, and now I'm doing midweek shows, that's how much information I'm giving out. every time I'm doubling up how many clients I have, how much money I'm making, cutting in half how much time I'm spending on my practice. If you notice, I'm doing more and more videos. I'm getting more business, but I'm making more videos, which is just spending time and not really direct relation to getting clients. But it's because I'm not going at it from a mindset of scarcity, so I don't feel that competition where I need to like stop other people from being successful. And it's so weird. It's so weird. I still see immigration lawyers I'll meet with and I'll talk to, and I'll ask them about what's going on in their cases, what's this, and they'll be so hush-hush about their practice, like it's some sort of nuclear CIA secret or something like that. I'm like, dude, get over it. Look at my podcast. I'm talking about what I'm doing all day. I'm letting people know, so they don't make mistakes with people's lives. That's the most important thing about this. And it's because I really come to tune of this nature that there's an abundance out there. And it's a new lawyer mentality. This is a new immigration lawyer, a new lawyer, a new human being, that by sharing and helping each other grow up, we're bringing each other up. Instead of trying to push someone down to make myself feel better, I'm going to bring someone up with me, and there's enough pie to go around for everybody. It's just a matter of using those resources properly and not wasting them, which is easy enough. But by bringing everyone up, you can really put a place for yourself at the table that's just growing. It's a paradox, and it goes against what historically has been the case for human development. But that's really the next evolution. And so when we're talking about this stuff, say people, you have white privilege, you say you're a racist, this and that, it's all true, but that's not going to get anyone anywhere. We got to go deeper in that, peel that layer off the onion and go much deeper and say, well, how can we make it so we all get a piece of this pie? And as long as we're all eating and making money, mostly it's going to be happy. There's going to be some Looney Tune crazy people that are always going to be hating stuff like that. But the vast majority is an economic decision. That's the reason why Trump was elected. Go look at the precincts that voted for him. They were losing out, and so they're like, oh, this guy is going to do NAFTA, change something in NAFTA. They probably don't even understand what NAFTA is, but they'll do some change with it. Or I'm going to bring back the jobs and mess around with international currency flows. And so they don't understand what this all means, trade sanctions and trade embargoes. They don't understand how stupid that stuff is, but it sounds good. It sounds like potentially I'm going to make more money and not be in debt, which we all are. This society is based on massive debt, which is a very scary thing. Not only just student loan debt, house debt, car debt. It's a lot of pressure for people. But it really has to, the evolution is what talks about it. Say, hey, listen, you got to work a little harder to force yourself to evolve. And look at things differently, work together, find ways of bringing in revenue. And what we do as immigration lawyers is so special because we're help rebalance the currency flows of the country. Trump talks about, China undermining his currency, so it's this and that, all these trade flows of US dollars going overseas and not coming back because we're not producing. As an immigration lawyer, I have foreign people sending me money to be able to do this work. So especially when you're looking at EB-5 and E-2 investor visas, hundreds of millions of dollars coming into the U.S. from foreign nationals, balancing out the trade currency issues are spending all this stuff or buying from China. So it's more deeper, it's more thought out, this stuff, but it's really our job to help explain this stuff and hopefully get some people listening and eventually grow it over time. So it's really a new world we're entering. And I read a book, and I posted on my Instagram and LinkedIn page. It's called Merchants of Truth. It was the former New York Times editor or the chief of newspaper, whatever the title was there. And she really goes into the fact that the newspapers were falling apart. They're at a high in the 2000s, but once the internet came and people were getting the news and publishing online and getting links to those newspapers on the digital version, they were taking massive hits, especially when Facebook came out and Vice News came out and all these different factors. They were just eating their lunch and they were losing money. Washington Post, New York Times, the small papers, local ones were just disappearing. And so then the newspaper was like, well, what are we going to do? Hey, let's jump aboard and give Facebook all our news articles so that people will follow the link, go to the newspaper, potentially buy it, or see our advertising. Well, the only thing that happened is it helped Facebook grow and all these other news aggregators grow faster, and the newspapers were losing. And it wasn't until they realized, that this new tech is coming, but the way to deal with new tech isn't to just, one way, don't get involved with it, be scared, or jump on board who the leaders are and try to beg them for a piece of the pie, but it's do internal evolution to grow and find how it works. Because how the newspapers are doing it when they try to do that is, they just took the printed newspaper, essentially took a photo of it, put it online, so people could click on an article to read it like that. But they said, especially Jeff Bezos, the Washington Post, where he was like, no, we got to redefine how the newspaper works in the digital age to make it work. And he's been reshuffling things. Some of the old school editors were annoyed and frustrated, but that's old ideas. Don't be stuck in there. You have to evolve. And he changed it up and turned it out where they're making a profit. And so we as immigration attorneys have to do the same thing, in a sense that the old way of just us hogging on to information about what the visa bulletin is and which forms you need, that stuff's over. That's all over the internet, what forms you need, I-64, I-130 if you want to file adjustment status, all that kind of stuff. We got to take it to the next level. What kind of content and value are we bringing? And not to be afraid to share information with people to help them, but let them know their complications and explain what they are. And if they want, they can hire you, and you can charge the fees that you want. And that's the business model I've used, and it's been working. So it really, I read that book about newspapers. I saw, yeah, they didn't know what to do. They jumped aboard trying to get some pieces from these tech companies, and a lot of lawyers doing the same thing. I keep seeing these websites pop up that do automatic O1s, and if you need to talk to lawyers, $20 an hour, or this and that. It's like, dude, don't even do it if it's going to be that cheap, because you could go work at a grocery store that cheap. Why'd you even get a law degree? That's like bare bones stuff. It doesn't let you connect with clients properly. And there may be a place for that because some people can't afford it. But that's not, if you're listening to this show, that's not where you should be. If you're taking the time to better yourself by listening to this program and learning and thinking about immigration law in your free time, that's definitely not the place you want to be. There'll be the market has different segments. They have that. There's a McDonald's for every, Gordon Ramsay or whoever the fancy expensive chef is, and market all in between. But if you're listening to this program, you're more dedicated to your practice to need to grovel over, $2. You need to really elevate yourself and evolve and find ways to connect with your clients so they know about you and they want to work with you, and the money isn't hesitation because they see the value you could bring by making them feel relaxed about what they're doing, walk them through it, and control the situation as best as possible to ensure the highest level of success. And at the same time, bringing more value, whether it be, connecting with them, talking with them, finding them work, finding them connections, all the different things you could bring as an immigration lawyer that knows so many people across the community. It's just so much value added that it's just growth. And again, it's not about being afraid of competition. The only competition you have is yourself. There's no need for desperation. What you have is a skill that takes years to fine tune. A robot, a computer can't take that away. Maybe some basic cases they can, but they'll be full of errors. They can't deal with the human experience, dealing with clients, talking to them. And that may require you to be a lawyer that has more empathy, that is a better speaker, connects with people better, which is a problem we see in the legal field where the lawyers are so detached. That might require you to grow more. That's really about looking at yourself or getting involved, with a coach that could help you or something. Talk with your family, talk with people, care more about people, and get into just evolving that. So I wanted to end with that point and the next one, which is throughout the years I've had a lot of lawyers who just wanted to get involved with immigration. They might have been criminal attorneys, bankruptcy attorneys, workman's comp, that were frustrated and tired with the kind of work they were doing, with the grind that it had, with the bigger picture of what they're doing, and seeing what's going on in the immigrant community, being families, being immigrants, and they just wanted to be part of this. And so over the years, behind the scenes, I've been helping and educating them in different programs and training. And I've just gotten so many more people asking for this kind of help, and so many students, attorney students, that I created a program that I've been doing. And it's behind the scenes working with these students. And I don't want to make it a full-scale program yet because I enjoy the one-on-one and just learning about what the students need and adjusting it. But I have room for a few more people, a few more spaces of some students across the country to participate. So if you were a lawyer in another field, you're listening to this and you're thinking about switching, send me an email at info@immigrationlawyerstoolbox.com. And we can have a time to discuss what this program is and what strategies there is to help you, enjoy your life and do good work. And also, along with that, a lot of other immigration attorneys have reached out who wanted to know how to do this digital marketing, how to get this experience of just getting a flow of leads and picking the best cases that you want. And so, because that program existed in the training I did to non-lawyers, I thought, well, I'll just take that one aspect because, the people are immigration lawyers already. I don't need to explain the visa bulletin and admissibility, adjustment of status. They already know this stuff. But that segment that's really key of how to do online and digital marketing, which I had to read every book and watch every video to get and continue to do. I have a program for that as well. So you can reach out. I'm only taking a few students right now, but if you soon after this reach out, the email is info@immigrationlawyerstoolbox.com. Let me know what your background is and what your interests are, and we could have a call to see how my program can help you realize your goals and your vision. Because you really need to have a vision of where you're going. It shouldn't be that you're just doing immigration law to make some money for the next month to pay the next bills. It should be much grander than that. How many people could I help? Could I help 10 people this month? Could I somehow 10x it and help 100 people? And then at the same time, could I 10x how much I'm making so I have more money, have free time to take on some complicated cases, or to become political because I'm not worried about the consequences of something hitting my cash flow because I have enough buffer to go around. It's just so many ways to think about it. The key is to live a life that has a vision and go towards it. And I want to help people because I've been contacted by so many people. I know vast majority have this missing center that you need to fill of getting what that vision is, which is hard, and then finding ways to it, which is really doable in this internet economy that we have, and I want to do my best to help you there. So my email for that is info@immigrationlawyerstoolbox.com, and if you had other questions, feel free to contact me as well. The video for this program is going to be on the YouTube page for Immigration Lawyers Toolbox, also on the LinkedIn page. Please follow there. I put a lot of information out there as well. But with that, I hope you had a good midweek, and until the next podcast on the weekend, I hope you have a great one. Bye-bye.